Hello everyone, we are starting with our lecture series on Hindu law. This is an introduction video and this video will be useful for candidates preparing for judicial service, LLB students, CLAT undergraduate and postgraduate students as well as to UGC candidates. Before moving forward, we must know what is Hindu law. We all know that India is a secular country consisting of many religions like Hindu, Muslim, Christian, Parsi, Jew, many religions, right? So Hindu law is one of the law of religion. We all know what law of land is, like constitution. It is law of land. Similarly, there is law of religion, basically for Hindus, that is Hindu law. It is one of the oldest pedigree of any system of jurisprudence. It is positive law and based on the concept of dharma. So what is a dharma? Dharma is aggregate of duties and obligations or anything which is right, just or moral. Now, if we talk about the major caste in Hindu law, there are basically four major castes: the Brahmins, the Kshatriyas, the Vaishyas, and Shudras. Brahmins are the priestly class, Kshatriyas the warrior caste, Vaishyas the agricultural caste, and Shudras, though rated the lowest, but still constitute an important part of caste system in Hindu law. Now, talking about the sources of Hindu law, they are classified into two: the ancient sources and the modern sources. Now, what are the ancient sources? You can see Shruti, Smriti, custom, digest, and commentaries. We're going to learn about them in the next slide. The modern sources are justice, equity, and so, what is Shruti? Shruti means which has been heard. It is synonymous of Veda and is revelation through अनुभव और direct experience. कहा जाता है कि जो भी ऋषि और मुनि थे उन्होंने अपने अनुभव के द्वारा जब भी वो एक अपनी स्पिरिचुअल पीक पे थे तब उन्होंने वेदों के बारे में लिखा था. अब there are four types of Vedas like ऋग्वेद, यजुर्वेद, सामवेद, अथर्ववेद. अब भी ये नहीं पता कि इनका ऑथर कौन है. That is why Shrutis are authorless. And when we will talk about Smritis, they are authored. Each Veda consists of four parts: Samhitas, which are the original writings; the Brahmans, which are interpretation of Samhitas; Aranyakas, these are the forest teachings; and Upanishads. We all must have heard about that. That is the secret and sacred messages. Now, if we talk about Smritis, Smriti is what is remembered or recollection. Like Shruti is which has been heard, Smriti is what is remembered. The main difference between Shruti and Smriti is that Shruti is authorless, whereas Smriti is authored. Some of the famous Smritis are Manu Smriti, Narad Smriti, and Yajnavalkya Smriti. Smritis also include epics like Mahabharata and Ramayana. If we talk about the commentaries and digest, several commentaries and digest matlab Nibandh, they were written on Smritis, and these commentaries and digest have given rise to the schools of law, namely Mitakshar school and Dayabhag school. Okay, एक और important point है, whenever there is a conflict between Shruti and Smriti, Shruti must always prevail. Now the last part of ancient sources are customs. Customs जो है वो oldest sources of law है. मनु रिगार्ड करता है कस्टम को एज डायरेक्ट एविडेंस ऑफ लॉ. इट इज अ रूल which through long usage has obtained the force of law. This is the definition of custom. There are many kinds of customs too, like local customs which are prevalent in particular region or locality, the class customs which are prevalent in particular class, whereas the family customs, these are the customs binding on a particular family. If we talk about the essentials of a customs, these are ancient, certain, reasonable, and not opposed to public policy. Okay, let us talk about the modern sources. Number one is judicial decisions. We all know what judicial decisions are. We must remember that decisions of Privy Council and the Supreme Court are binding on all courts, but decisions of High Court are not binding on other High Courts. जैसे अगर पंजाब एंड हरियाणा हाई कोर्ट कोई डिसीजन दे दे तो मद्रास हाई कोर्ट पे वो ऑर्डर बाइंडिंग नहीं है, बट अगर कोई भी सुप्रीम कोर्ट कोई भी ऑर्डर दे देती है then that order is binding on all the high courts or all these subordinate courts in India. Another interesting point is that हिंदू लॉ बहुत टाइम पहले जब एडमिनिस्ट्रेट किया जाता था इंग्लिश जजेस के द्वारा, तब वो साथ में हिंदू पंडित्स को रख लेते थे. इंग्लिश जजेस अपने साथ हिंदू पंडित्स को रख लेते थे एज अ रेफरी, बट लेटर दिस practice was also abolished. If we talk about legislations, we know before independence there were many legislations like Hindu Widow Remarriage Act, the Indian Succession Act. These legislations were related to Hindu law only, but after independence only 4 legislations are basically used in Hindu law. These are Hindu Marriage Act, Hindu Succession Act, also 2 more like Hindu Minority and Guardianship Act of 1956, as well as the Hindu Adoptions and Maintenance Act of 1956. Now the last one will be justice, equity and good conscience. Now consider a situation where no rule of Hindu law applies and also there is no proof of existence of any custom. In that case, rules of justice, equity and good conscience will apply. And if we go to the history also, there are many cases in which the principles of justice, equity and good conscience have been applied. Thank you.